Hi, today I want to talk about Rogers versus the estate of Ashlock, which is a federal court case out of Alaska. This case illustrates that it's important to be aware that there are certain deadlines associated with bringing claims. Rogers suffered a hernia when a freezer fell on him aboard the fishing vessel Dutch Harbor. Rogers alleged that his vessel employer failed to provide medical treatment and forced him to continue working after his injury. Almost 3 years passed, and then Rogers fell on the deck and re-injured his hernia. He filed suit for both incidents against his employer and asserted that his employer was negligent under the Jones Act, that the Dutch Harbor was unseaworthy, and that he was owed maintenance and cure benefits. His employer asked the court to dismiss his claims because they contended that his claims arising from the freezer incident were time barred because more than 3 years had passed before he asserted his claims for that incident. The court agreed that his Jones Act and unseaworthiness claims were barred. However, the court allowed him to pursue his claim for maintenance and cure. The important takeaway for vessel crew members is that there are certain time periods to be aware of in which you must bring your claims, and you must not delay, or else you'll be prohibited from recovering for your injury. For example, you must bring claims for Jones Act negligence and unseaworthiness within 3 years of the incident. While a claim for maintenance and cure is not governed by that 3-year limitation period under the General Maritime Law, it's still a good rule of thumb not to wait any more than 3 years to bring your claim for maintenance and cure benefits in order to protect your claim. If you have any questions about your claims, please call me at 504-500-5060. Thank you.